be ready for our next legal dictation, Right to Life and Personal Liberty, Part 1. Be ready and start. Article 21 covers right to life and personal liberty against its unlawful dispossession by the state, and if there should arise an occurrence of suspension of Article 21 by emergency under Article 359, the court cannot scrutinize the expert or lawfulness of such state's choice. Stop. Article 358 is significantly more extensive than the Article 359 because on one hand all the fundamental rights are suspended as entire according to Article 358, but on the other hand Article 359 does not suspend any rights. Stop. Notwithstanding being emergency arrangements under Article 359 within bracket 1 endow unique power and status on the executive, it does not undermine the indispensable elements of the sovereignty of division of powers, prompting to an arrangement of what is known to be a system of checks and balances and constrained authority of the executive. Stop. The nexus amongst state and executive is flawed, and the impact of suspension of such rights will emerge in the form of additional energy in the hands of the legislature, which may formulate laws against the fundamental rights. Stop. This act ought not be considered as a power of the executive or right of it. Stop. There is a legal and reasonable degree to which a state can act in or against the people, and for this situation it by high abuse of powers of individual political profit of a particular individual. Stop. Amid emergency, it is nowhere talked about that the authority of state increases from its original control under Article 162. Stop. Additionally, the state just holds the privilege to arrest if the supposed act falls under Section 3 of and its each condition is satisfied. Stop. In the event that any condition is unfulfilled, then detention is past the powers of state. Stop. Para. Deprivation of personal liberty, which inter alia includes the right to eat or sleep when one likes, or to work or not to work as and when one pleases, and several such rights sought to be protected by the expression personal liberty in Article 21 is quite different from restriction bracket, which is only a partial control bracket clause of the right to move freely bracket, which is relatively a minor right of a citizen bracket clause as safeguarded by Article 19 within bracket 1 within bracket D. Stop. Deprivation of personal liberty has not the same meaning as restriction of free movement in the territory of India. Stop. This is made clear when the provisions of the Criminal Procedure Code in Chapter 8 relating to security of peace or maintenance of public order are read. Stop. Therefore, Article 19 within bracket 5 cannot apply to a substantive law depriving a citizen of personal liberty. Stop. I am unable to accept the contention that the word deprivation includes within its scope restriction when interpreting Article 21. Article 22 envisages the law of prevention / preventive detention. Stop. Therefore, when the subject of preventive detention is specifically dealt with in the chapter on fundamental rights I do not think it is proper to consider a legislation permitting preventive detention as in conflict with the rights mentioned in Article 19 within bracket 1 stop. Article 19 within bracket 1 does not purport to cover all aspects of liberty or of personal liberty stop overall.